Hi, I'm Anna Denton-Jones of Refreshing Law, and in today's session I want to return to the topic of holiday pay, and in particular the issue that emerged last year in the Bear Scotland case, which I have previously discussed in one of these videos, which, if you remember, was the case where it established the principle that holiday pay as calculated by an employer isn't necessarily now only going to be based around basic pay, but the employer should actually be looking at other regular payments that are made to members of staff, such as overtime, such as commission payments following the Lock and British Gas case, other allowances and bits and pieces that make up somebody's normal pay packet, so that when somebody takes time off on annual leave, they're not penalised and suffer a shortage in their pay packet as a result of not getting the full picture, if you like, reflected in their wages. Now, one of the things that came out in the Bear Scotland decision was around overtime and the extent to which overtime might be deemed to be voluntary overtime, which the employer isn't particularly guaranteeing to the staff, and when might that be caught by all of this. And I've for a long time been arguing that the direction of travel here is pretty clear in the case law, and that if payments to staff make up part of their normal pattern of doing things, where it's intrinsically related to doing their job, then the law will find that it should be included in holiday pay. And we had a Northern Ireland decision of Patterson last year that suggested that just because you termed voluntary overtime as being voluntary, that wouldn't necessarily preclude it from being captured by this way of looking at things. And now what I want to talk to you about today is a new case, the first case in England really that has followed this line of reasoning. It was a case in Dudley involving Dudley Metropolitan Council, and they'd engaged 56 tradesmen who were all members of a particular trade union who chose to bring a case in relation to this issue. And they'd been working on Saturdays on a voluntary basis to perform repairs to some housing stock, and they were also on call-out rotas and got standby payments and payments when they were on call-out. So the issue for the tribunal, and it is just a first instance decision at sort of first level in the tribunal system, was whether or not, when holiday pay was calculated for those guys, whether or not it should be calculated looking at their average earnings, if you like, over a 12-week period before they took the holiday, calculating including obviously their overtime and other bits and pieces that they were getting, or whether it should just be their basic pay. Now, I'm not at all surprised that the tribunal found in favour of the 56 tradesmen. Whether or not Dudley will appeal this, we'll wait and see. But I think it shows that that direction of travel really is here to stay. So if you are an employer that pays people a variety of different kinds of allowances and bits and pieces over and above basic wages, then you do need to look really carefully at how you are paying holiday pay and make sure that you are including everything in the calculation that you are making. If you've got any questions, please do contact me. It's adenton@refreshinglawltd.co.uk. Thank you very much.